Joseph Kotrie-Monson, our legal eagle, who's broadcasting live from Oxford University, no less. Looking
indeed,
at all the lovely wood behind you.
University College, my alma mater. Very grateful for the time I had here.
It's very nice. Now, just on this is an interesting one. And we're talking about, we've been talking about marches, and I'm just saying, if anybody's going to do any disruptions, maybe it be just stop oil and what have you. It's an interesting one, isn't it? What about these cases with Extinction Rebellion? The co-founder was found guilty of damaging government property building. This is Gail Bradbrook. But what's interesting here, most interesting, is during the subsequent legal wrangle, Judge Edmund Casey proposed taking the highly unusual step by ordering a juryless trial under organised crime legislation unless Bradbrook followed directions about the scope of her evidence. This is about, is it not, people from Extinction Rebellion in this particular case, or climate change people. Ostensibly, they've been labelled as using the court as a loudspeaker or a platform for their beliefs in their defence. Am I right in that? And the court is saying you can't do that? You
can't do that. And there's something to be said for that, although in various articles, it says that there's a general trend, Trisha, towards a crackdown on those types of cases where the justification for your actions that you're trying to persuade the jury of is a wider argument on social utility and stuff. And it's actually a history in kind of libertarian lawyers' toolkit that goes back, I guess, around 40 years ago. Mike Mansfield Casey, you hear me talk about sometimes. Vera Baird, now Casey, and a police and crime commissioner and victims commissioner, I think, who was a Solicitor General at one point. They pioneered this way of defending people on the basis that their actions were directly linked to something else which is sacrosanct in law, for example, the protection of life. So, for example, we had attacks on military installations or attack helicopters where it could be proven to the jury that those helicopters could be used to bomb innocents. And of course, you can see how there's a nexus between the disruption of that activity and what those devices or whatever helicopters, weapons might go on to do. Even the Colston slave trader statue case, if you remember that being toppled, that was very interesting. There were barristers in that case on behalf of the defendants. Well, they said that that statue's presence was an ongoing crime against the people of Bristol. And the jury liked the argument. And perhaps you can see why. The guy was a slave trader in Bristol, a multi-ethnic community. But Trisha, this case, this Extinction Rebellion case, Bradbrook, is different because she's not using lawyers. She's either sacked her lawyers, I suspect.
Oh, she's doing it on her own.
Doing it all on her own. And it's very difficult to make the connection between making a big speech in the centre of London, wherever it was, causing 25 grand's worth of damage to plate glass at an HS2 office and the actual building of the railway. What's the connection between those things like you had in the other ones? All those other cases involved attacking the thing that you're trying to stop in a meaningful way.
She was just attacking a building.
She was trying to draw attention to a cause by causing that damage. Well, hang on a minute. Well, why not justify in that case attacking somebody from HS2? That would similarly, I'm not advising it, but that would similarly draw attention to the cause. Would we regard it as justified? Of course we wouldn't. It's far too removed. But the trial itself was fascinating because untrammeled by the advice or assistance or impedance of her lawyers, she tried on 2 occasions to turn her trial into this long set of political speeches. No lawyer would have advised that. The first trial, it was such a dirty dogfight that the judge ordered a mistrial. The jury were left prejudiced and confused because what she was saying in her long speeches about climate change wasn't legally relevant. There's no defense in law. Now, I'm not saying that history won't judge her well. It may well do, but she is in the minority of, and if she wants to change the law, she campaigns for a change in the law. So the majority agree with her. The politicians vote it in, and then she can have her speeches, but at taxpayers' expense to do it now, paying for judges, paying for prosecutors and all of that jury time. Well, you know what? I don't particularly agree with that, even if I'm very sympathetic to her cause.
Yeah, it's not what you say, it's the way that you do it. Or so not what you do, the way you do it. Thank you so much, Joseph Kotrie-Monson there with our roundup of all things legal.